gun. Yeah. Put you in the sickle for the harvest is right. We ain't down for wickedness, false prophets a lie. Woman to the wicked grass of blind to sight. Unquenchable flame, stars fall in the night. Shemayim snapped the scroll, mountains fled in the anger. Hills a flock of rams, skipping special forces, recon angels. Really about no labels, we bout labor for the source. Wells up in infinite, waters coming forth. Spiritual revival, dehydration shall I pour. Kept the run down to the mouth, cool floor. Kingdom heaven in me is parts of the morbid head. Treasure like deep in you, key to the never end. We all a ray, a fragment piece of the sea sledge. Point of a center, he segment filled in with ether. Hit me on the end, you're passing the present teacher. Pre-sealed and covered in Nehemiah, not Easter. We all a ray, a fragment piece of the sea sledge. Point of a center, he segment filled in with ether. Hit me on the end, you're passing the present teacher. Pre-sealed and covered in Nehemiah, not Easter. Not a game, stolen the soul arrangement. Adversary in the details, mirrors and smoking angels. Incriminating emails, fake news, read the paper. Pimping who been printing, it's all designed to take you. Division in your cells, almighty sustain. Ain't got how relying on nothing else. In trouble, it's all vapor, elder wind in the sails. The water, the whole rainbow, reclamation, just a vessel, a wrestle. Jonah, you came for. Stay mind, grow it holy. Lord, if they only knew how they controlling you, thought still a slave. Look how they holding you, enemy scoping you, word on my way. Stay mind, grow it holy. Lord, if they only knew how they controlling you, thought still a slave. Look how they holding you, enemy scoping you, word on my way. Force tremendous, Bill Adam breath, living dust, mushy for the enemy, burnt down like a Dutch. Once upon a distant, dirty sackcloth in the ashes. Truth don't grow with mischief, prayer get raised about the ashes. Save me from the mire, I would fell if not your pasture. Had you not an anchor, if you save me, I'll be thorn. Thorn to the thief, leech, mind to the corn. Stone in the sling, sing signs in the storm. Rock foundation, time echo with the north. Recon over game, wings fly with the force. All purpose type material to camouflage the course. Tiger stripe, orange, red, drip from the source. We all array, your fragment piece of the sea sledge. Point of a center, he segment filled in with ether. He'll be on it then, you're passing the present teacher. Pre-sealed and covered in Nehemiah, not Easter. Stay mind, grow it holy. Lord, if they only knew how they controlling you, thought still a slave. Look how they holding you, enemy scoping you, word on my word. Stay mind, grow it holy. Lord, if they only knew how they controlling you, thought still a slave. Look how they holding you, enemy scoping you, word on my word.
A guy, or you could be a one woman who stays with one guy for eternity. God bless you. Or you could be the bed hopper. The bed hopper obviously is going to have her point of view, the benefits of bed hopping, and obviously the woman who stays with one guy is going to have her benefits of why she believed the same thing that he did.
Constructive fraud.
Okay.
When the fraud is built into the system.
Right.
Constructive fraud. Okay. Now the really cool thing, the thing is, if you could ever prove constructive fraud, there's no statute of limitations on constructive fraud. Okay. When there's a fraud by a man or a woman or somebody who's done something to you, you've got, even in their statutory rules, you've got a time limit in order that you can go back and defeat them. In their own rules, constructive fraud may be exposed anytime. If I wanted to prove constructive fraud by the Constitution of the United States, I could do it today, okay? If I could prove that constructive fraud, and there's no statute, I could do it today. So if somebody has committed fraud on you in a constructive fraud kind of a way, while they may or may not be personally liable for it, the system is liable for it, and it vacates everything and everyone that was ever ruled against by virtue of that particular error in system. Okay? So the possibility exists if you could prove constructive fraud. And this is what they do as a matter of course. And eventually, if you win your case, as you probably will, and go back and recruit 1,000, 10,000, 100,000 other Canadians to come and say, you know, we got pooped on in the same way, you could actually come up with a case that could prove constructive fraud and overturn and vacate all of those judgments that were ever made by virtue of that particular operation.
Okay, so let me stop you right there, Greg. Greg, stop. Because like I said, I could actually tell you a case where this is a true case. Believe it or not, it's going to sound goofy, but you got to be careful when you use the fraud, like constructive fraud or fraud in the inducement or fraud in the factum. There's a there's an actual case. I'm telling you, man, it's called Burrow versus the Superior Court. Okay, this is a funny case. This only happened in 1985. So we'll see if you can watch the silliness of this. The doctor, Dr. Stevens, called up the victim. Okay, and he's saying that he was Dr. Stevens from the hospital, and that the victim had a life-threatening disease. So he told her, he presented her. Believe it or not, this is true. This ain't a joke, with two options. The first option was to have a painful surgery costing the victim $9,000. You can Google this. It's BORO versus Superior Court, 1985. Two options he gave her. He said you could have a painful surgery that cost you $9,000, or she could have sex with him, and it only cost $1,000. Okay? So the victim had intercourse with the defendant, believing at the time that her life was threatened, and that was the only choice she had to cure this horrible disease. Okay? This is true. The victim, upon learning the truth, brought the charges against the defendant for rape. Okay? The court held that this was fraud in the factum, and therefore there was no rape. Okay? It was fraud in the inducement, because the deception related not to the thing done, the sexual intercourse, but merely of some collateral matter, like the cure of a life-threatening disease. So that's what he really did. So you got to be careful when you use fraud in the inducement or fraud in the factum. Like when you say fraud in the factum, fraud in the factum is more misrepresentation. It causes somebody to do something without realizing the real risk, the duties, or the obligations. It's like saying that, let's see, John tells it, let's say some guy tells his mom that he's taking a college course on handwriting analysis, and for his homework he needs her to read and sign a pretend deed. So his mom signs like this deed, believing that, you know, John said he's just trying to work on his lawyer skills. And well, John really has his mom sign this blank piece of paper or this deed, and then he fills in the rest. That's fraud in the factum. Okay, that's just flat out fraud. He just had his mom say, "Oh, I'm just doing some handwriting analysis skills. Can you sign this blank piece of paper?" So she signs a blank piece of paper, and he writes, "Well, you just transferred all your property over to me." Okay, that's fraud in the factum. See, fraud in the inducement is just a trick to try to cause somebody to do something to take away your real property away from you. Okay, it's right. Fraud, right.
And fraud in the inducement and fraud in the factum on the statutory side both have a time limit in which you can prosecute.
To a point. But when you claim that you're a man, you have no statute of limitations. Anybody do anything wrong, whether it's
no, but you know, like we were saying earlier, sometimes, you know, we as men can move freely in any jurisdiction we want. If we're going to go and operate in that jurisdiction, there's a time limit. There's a statutory limit to prosecution. And well, the point that I was making was that, you know, fraud in the system. If the system itself is fraud, there is no statutory limitation.
What I'm saying, that was a great example that you gave us, that it was fraud in the system. But if she signs a contract and she works with these people, then there's going to be a statute of limitations in what she can and cannot do, because somewhere she signed a contract. So they will have latches on that, built into that contract, what the parties can and cannot do, or what one side is liable for, what the other side is not liable for. But as long as she stays as a man or a woman and does not bind herself with this intercourse with this monster, this, you know, because she's afraid of some crazy home disease she's going to get, she stays away from it. If this monster ever tries to claim that we had an agreement, she knew all along, and she's bound by these statutes of limitations. No, she's not, because she never had a contract. She never talked to these people. Anytime these people looked at her in court, she was like looking at ceiling tiles, because she's like, "What? Are you talking to me? You got a claim against me? Is there a claim before this court?" "Yes or no?" "I haven't seen one yet." "Well, I got all those people." "Man, is that a claim?" "Well, no, it's a claim." I only answer the claims. I'm a man, I'm a woman. I only answer claims. I don't answer that. Anything else? Sir, Mr. Guy in a black robe, is that true? Does man only have to answer to a claim? Is there a claim verifiable before this court? Yes or no? No. And what the hell are we doing here? Well, they want to just talk jibber-jabber about the code and how you're never going to get your kids. Okay, great. Is that based upon a verifiable claim? Is this not a common law proceeding? No, this is an administrative code proceeding. So, you think I'm some sort of code decipherer? You think I'm going to sit here and try to get some jibber-jabber and try to interpret code? You think I should get a code interpreter here called a lawyer and attorney to decipher your jibber-jabber for me? No. I don't trust any of this, because the first duty of that attorney or that lawyer is to this court, not to me, is to the court and the rules established under those codes. His first duty isn't to the rules of common law to protect his client. His first duty is to protect the code. The rules of the law that are before this court, his first duty is to the law. The law before the court is the rules established by the other side. Whatever the other side established as the rules of the court, as the law of this court, that's his first duty to do. So if I try to tell my attorney to say this, object to this, he's going to tell me, shut up. They're in compliance with the rules of the court. You say, no, I got these rights. Not in this proceeding, you don't. You're the defendant. You didn't establish the rules. You don't have those rights. You will have them in common law, but you don't have them here. Shut up and sit down and stop. And she's like, but I have a constitution. You ain't got boo. I got the Great Charter of 1982. You ain't got squat. Sit down and shut up. The terms are written in the contract. There is no contract between me and the other side. What? What do you mean there's no contract? There's no contract. Tell them to bring the contract forward. Oh, they definitely have to have a contract. They have something that binds you to that. Oh, I'm telling you, Judge, they don't. Tell them to bring it forward. Tell them to bring a law before the court. And so then the judge says, is that true? Is there any contract? Is there any law before this court? And they say, well, no, sir. It's like, oh, my God. Do you realize what you're doing to these people? The other side knows exactly what they're doing to you. If there's no contract before the court, if there's no law before the court, they're filing a false claim. It's frivolous. It's a perjury. There's all kinds of words for that. For moving barratry, it's ridiculous what they're doing. Because, like I said, the very simple claim that I had Jesse do was basically saying, I, and then her name, and it says, claim the wrongdoer's trespass against my property. Exhibit A. And Exhibit A was the property. Number two was there's no law that exists which binds I to the wrongdoers. There you go. Just there's no law that exists which binds I to the wrongdoers. There you go. Is there any law that has the jurisdiction and control over me? Is there a contract? Is there something that binds me to the wrongdoers? No, I have no idea who these freaking people are. I've never seen them before in my life. They just manifested themselves in front of me one day, and I have no freaking clue what they're doing in my life, but I want them gone. Okay, that's number two. Number three, I require the delivery of all said property to be under my jurisdiction no later than April 18th, 2013. And number four was I will place a charge of $1,000 per day per said trespasser and said agency for any failure in the restoration of property on said date. Number five, if the placement of all said property does occur on and or before April 18th, I will forgive those who trespass of their debt as I would wish others to forgive me of my trespasses or my debts. That was the whole lawsuit. That's all you need for a lawsuit. Nothing else.
I've been in contact with an attorney over an account in Mississippi over a traffic citation that my wife received on Easter Sunday. And he proceeded to tell me that I was not entitled to discovery. And when I asked him what their standard of proof was, he said, what do you mean? And I said, well, is this a civil or a criminal matter? And he stated that it was neither. And that because of a law in Mississippi called implied consent, that I'm not entitled to discovery. She's not entitled to discovery. She's not entitled to basically anything. So he told me I've got three choices: guilty, not guilty, or contest the ticket. And I said, well, I don't have enough information to make an informed pleading at this point, and for me to contest the ticket would be dishonorable. So I need more information. And he goes, are you an attorney? And I said, no, sir. He goes, well, have you talked to an attorney in Mississippi? And I said, do I need to talk to an attorney in Mississippi? And he stated that it never hurts to talk to an attorney. Well, I got a little smart mouth with him, And I let him know what I thought about attorneys, and he hung up the phone on me. So I thought, you fellas, that's no beat.
Okay.
So I called back to the courthouse, and I explained to them that I've got a situation, and I need to speak to the judge.
Mm-hmm.
She took my name and number, and she left it in the judge's box, is what she tells me. So they haven't called me back. That was 3 days ago. But the little tidbit of information that I did get was that it appears that if I don't enter any kind of pleading at this point, they cannot move forward. They can't move the course unless they have basically my consent. So I wondered what you thought about him depriving me the right of due process and equal protection of law. I mean, is that valid in their court?
Well, like I said, to me, when you come dealing with what I'm saying, off the top of my, like I said, everybody has every human being on the planet, there's a law. Everybody creates their own law. But what the government recognizes, they recognize the way you would define law would be like categories like absolute law. You want to do it like a criminal law, administrative law, bankruptcy law, civil law. So like I said, if I just basically did it alphabetically order, which would be ridiculous, it'd just be like administrative law, absolute law, admiralty law, bankruptcy law, canon law, civil law, common law, constitutional law, contract law, corporate law, criminal law, ecclesiastical law, equity law, family law, federal law. So when you ask them, is this civil law? No. Is this criminal? No. Is it one of maybe these other 28? Possibly. Or maybe it's a private law established between a contract and you and Department of Motor Vehicles. I don't know. So like you could say to the other side, what law is moving this court? But you don't say it to the judge, you say it to the prosecutor. Who's moving the case before the court? Now, what did the prosecutor define the law as?
He gave me unsolicited legal advice.
There you go. What you need to do is submit a bill of particulars. You just say to him, okay, I got the bill. I got your bill. Now I got your invoice. Now I need the invoice statement. Give me the bill of particulars. And one thing I need to know in particular is what law is this? Show me the law that you're relying upon to prove your claim before the court, or complaint, I don't care, or civil law, bankruptcy, or admiralty, or all those ecclesiastical, whatever other law that I just said, because there's billions of laws, billions and trillions of laws. We read laws every freaking day. So just because it's not civil, no, it's not criminal. You people just think there's two laws. That's ridiculous.
I got you. So it goes back to establishing to know what, not venue, but what jurisdiction you're in.
Jurisdiction. What's jurisdiction mean? What's jurisdiction?
I guess jurisdiction to me means the place of action.
No, that's a venue. Jurisdiction means gives you the right to control me. Control and jurisdiction is the same thing because our contract controls you, and you perform a certain duties, obligations, and functions, and you have certain privileges and rights ascribed within that contract. Okay. There you go. That's jurisdiction.
I'll do some research on bill of particulars then. Thanks, Karl.
Right, because if I can jump in real quick, because what the legalese people are going to tell you is that it's got to be either in res, in rem, or in personam. And
when it comes to legalese.
Or subject matter. Right. I said that at the beginning. I said the legalese people will tell you it's got to be either in res, in rem, in personam, or subject matter. Okay? The whole point of it is that you cannot have in res, in rem, in personam, or subject matter if the law does not apply. Well, the law is the jurisdiction.
If so much the law doesn't apply, if the law does not exist.
Okay. It doesn't apply or exist. The other I said.
He was attempting to misfly a statute to me.
It doesn't.
And I didn't want. I know it doesn't matter. I didn't want to get into it with him at that point. But even reading the statute, I believe he's committing constructive fraud.
That's okay. What I'm saying, he at this point has the whole. He has the gun. He has the whole ball of wax. It's his court. It's his court. It's his claim. It's his complaint. You haven't established court yet. You haven't filed a counterclaim yet. So you can't be a defendant. You want to be a defendant, you're going to get clobbered. So you want to operate under his law. You've heard me talk about this many times, right? You've heard me.
Yeah.
Okay. You have to understand. You have to establish your own claim. Okay. and say that they're moving this court with no claim before this court. There is no law before this court. Where's the law? I've asked him a million times, where's the law? And he has to produce the law. And he can't do it. He can't do it verbally. You want to see it in writing.
In writing.
Don't make them say, well, under Mississippi Code 28. No, you put it in writing. You show me. You show me. So you start square one. And you're not ready to proceed in any kind of tribunal or hearing or dispositional matter or trial until you're ready to go. You're going to stay in the proceeding. You're going to stay in the proceeding until you're confident to stand. Until you understand how the hell do you, I still don't understand how you're doing this to me. You're going to have to show me. Keep showing me. Keep showing me. And when it comes to a civil matter like this with the state can't force you to be confident until you're ready. You just keep playing this ridiculous, if you want to do English common law, you can play this volley back and forth all the time. You know, as somebody files a complaint against you. And then it's in this subjection, and then it's a counterclaim, and you just keep volleying back and forth because this guy really don't care. Because the reason why he doesn't care is because he's getting paid. He doesn't going to care less if this goes on for the next 20 years. And while that ticket is outstanding like that, they're gonna convert that ticket, that citation. They're using it as proof that there's that value of the ticket, $100 ticket, and they're investing that $100 ticket. And you know how people are trading on a derivative and all that up.
Right. They're claiming it as asset.
Right. But what I'm saying is when you get to the certain point, I don't know if you've heard of it, see my thing, heard my stuff. I love tickets. I love citations because I'm going to file a counterclaim. And whatever the value is on that ticket is going to establish prima facie proof that ticket, that citation is worth $100. So not only do I believe that's worth $100 and he believes it's worth $100, well, now I believe not only is it worth $100 for the citation, but that proves that now you've wasted my time, my resources, my energy, my patience, and I'm going to not only claim all equity in that citation, but I'm going to place damages of wasting my time for filing a false claim against me. So I love tickets. Explain to the folks how you would deal with in a summons to appear for a credit card debt or any kind of debt. Let's just do that. Let's make it blanket. What would you do if somebody claims that you own a debt? And how would you proceed? Because you're doing it exactly like everybody does. So,
well, first of all, it's not a summons to appear because we're still in the private going back and forth. From the beginning, you know, you're already jumping all the way to a summons to appear. I ain't going to go there. First thing happens is guy sends me a letter. It says, you owe me this money, pay it. I go, okay, who are you? I want to find out who you are and validate the fact that we have a relationship and find out if there's actually a deal or a contract or if there was anything made or if it's just some crazy son of a gun from Arkansas trying to, collect money from some poor guy in Chicago. So anyway, after you get that settled, you go, okay, I guess we really do know each other, and I guess we really do have some kind of a deal. So what's your claim? All right, well, I think you owe me $147.25. Okay, for what? Well, stuff. I don't know, stuff. What stuff? Okay, well, you know what? You know, that's great, but why don't you give me a validation? Why don't you send me like an itemized true bill or a bill of particulars that says this is a deal and this is what happened? Okay. And by the way, why don't you include a copy of the contract, if there is one? All right. So time goes, and you get something which is on the order of, we don't care what you want, you're going to pay us anyway. Then you go back and say, okay, well, I believe you're a franchisee of the federal government and the banking system, which means you have to follow certain rules, so RESPA and TILA and everything else. If it's residential mortgage, it'd be RESPA. If it's credit card stuff, and that'd be TILA. And so, you know, you got to jump through these hoops. You know, that's, you know, you might win at the end, but the federal government at least gives me the opportunity to put these barrel hoops up in front of you so I can watch you jump through them before you take my money, so I can at least be entertained for the money I'm about to pay. Why have to pay something to somebody without entertainment? So you got to jump through hoops. But if they refuse to jump through those hoops, then you can go, aha, we've caught you, because the federal government said for you to keep in good standing with your franchise, you have to be able to do those barrel hoop jumps. And Greg asked you to do that, and you didn't, so you're a bad boy. Now, I've got a cause that I can go after him and say, here's your last chance to jump through those barrel hoops. You got to prove all this stuff. And let's say, obviously, if they don't perform, then that becomes an actual justifiable claim to say, I don't have to pay anything, all right? But let's say, just for the hell of it, that he does perform. He's the 1 in 1 million creditor who goes, you know, I totally understand the rules, and I'm not going to be a poop head, so here's all the stuff I got. And you go, holy shit, this guy actually gave it to me. Wow, that's kind of cool. But take a look at it. And then you go, okay, this. Okay, do you have first-hand knowledge that I actually did these charges? Do you actually know that I did all these things? Do you have anybody that will witness that I would do that? Or is this just stuff that showed up on the record and went unrebutted because I didn't know and you didn't know, but now you decided to collect on this? And, you know, hey, maybe we're dealing with an alien using credit card numbers. Who knows? Or somebody down in Arkansas trying to steal money from you. Who knows? So anyway, you can play all this game and you go back and forth. And in a worst case scenario, if you decide to acquiesce and say, okay, I owe you money, you say, I'll give you $1 a month. And he'll go, no, that's not acceptable. I'll say, I'll give you $1.50 a month. Oh, that's not acceptable. So, well, that's all I got. And you can say, sue me, takes you to court. You document all that stuff. You go to court and you tell the judge, look, I, in good faith, offered this guy. Matter of fact, I sent him a check for this and this, and he either cashed it or sent it back to me. And he refuses to deal with the fact that I've got, you know, a hardship situation here, and I was trying to stand in good standing with him, but he's just being a poop. And the judge will throw the book at the guy for, you know, not being honorable and accepting your best effort. And that's usually what happens. Nobody ever, or rarely ever, throws the book at you if you've actually got a history and recorded piece of data that says, a recorded record. I'm being redundant to say a recorded record, but information on the record that that indicates that you are actually operating in good faith to the best of your ability, because you can't get blood out of a turnip. And if you can prove that in the statutory court, you can actually win. Karl's got a great case of a guy getting a sofa for nothing because the creditor was being a poop head. And so that can happen. You can win in your favor. Or if it's in equity, of course, the judge could come up with some kind of a compromise. You know, say, okay, you know, on alternate months, do this, do that, and the other guy does this and that. And if you're in equity, just say, okay, thanks a lot, sir. Have a nice day. If you absolutely want to dispute the claim, then you can try to, you know, challenge the contract as to whether or not it's valid. You can challenge the law as to whether or not there's any law that says you have to pay them. You can challenge a bunch of other things. But after that, you start going into more esoteric stuff that some people do. Some people actually challenge whether or not the currency is valid, or if everything is already prepaid, using your birth certificate, bond, et cetera, et cetera, et cetera. And there's like, from that point, you can branch into like 12 other things that people do. So that's typically the scenario that people run into when they get popped on some kind of a credit card debt. And I'll leave it at that. And that's kind of like the overview. So, Karl, what do you think?
That was Greg. He kind of slammed it there pretty quickly. What me and Greg were talking about earlier. We were just basically saying step by step how you do it in court. And like I said, Greg went through this just like lightning just now. And all we were basically trying to say earlier was that my method is just to say when you're being summoned to appear, you did everything on the private side. All you have to say to the folks is, I just need to see the law before the court. That's all you need to do. But like Greg was trying to say, and I'll try to do it a little Greg was saying, is first you make sure that there's joinder between the parties. First you make sure that you know each other, that somebody's not just moving a claim or a debt in front of you in error. It might be just a mistake, the same spelling of the name, whatever. The next thing you just need to do is then you just say that, just bring forth the obligation of the debt. Just show proof of the obligation of the debt. Say, you know what, honestly, I don't remember you. Honestly, I don't remember having any business dealings with you. Or you could say, honestly, I don't remember that number being that exact amount. How, and like I said, everybody knows you can look into your local state courts, the rules of the courts, or you guys code the Code of Idaho, your state codes sections.
Oh, I just remembered, Karl. Here's a real world scenario. My friend Brent, he got a bill from a credit card company that said they wanted like $200 and something, and this is a credit card that he canceled in about 1996, and he's not used it since then. It was an early thing that he had, and he hasn't used it. And so some debt collector got a hold of this account and put this stuff together. And because he did have that account at one time and he remembered it, they were counting on him to just go, oh, crap, I forgot that, and pay them. And he challenged them, told them to go to hell, and they went away.
All right. So what I'm saying is, yeah, let me let me go back to what I was saying there, Greg. All I'm saying is, first, you want to make sure that there's no error. Make sure that there's nothing in dispute. Make sure that first you want to make sure you try to settle on a private side. It's like, say, well, I have receipts that I paid you off. Maybe it's a computer glitch or a computer error. Maybe somebody who did data entry for your company failed to put this information in. So let me resend the information. I'll verify that it's true and accurate, and I'll show you canceled checks, whatever it is, to try to help you folks. Understand that this matter's been settled. So like I said, the only other thing you could do is, because every state code book has provisions within their code that if you're chartered as a business and you operate as under a license in your state, you have to abide by state codes. You can't just wing this and say this is a private affair, or this is a private matter, or this is a private business. You are now in the public when you're engaging with others, in the public. So all you're doing is, like I said, it's called statute of frauds. So a statute of fraud means that every single agreement that you folks did, and it started back in the 1600s, because actually it was started in 1677. Paper and pen became plentiful and cheap, and they weren't writing on sheepskins anymore. You could use cheap materials to write things on. And the people were starting to get educated by 1677. So any businessman was demanded of them to have it written in form of paper, parchment, sort of contract. It had to be written out, spelled out. Only to certain, under certain transfers of certain properties or possessions had to be itemized and had to be listed. Like, say you went to McDonald's and you went to the drive-in and you ordered $499 worth of ham. By the time you get to the window, if you changed your mind and you didn't want those $499 worth of Happy Meals, you could just say, I changed my mind. Or what Happy Meals? I didn't order any Happy Meals. I ordered a Big Mac to go. And the lady at the window can't call the police on you and say that you failed to, pay for the services, because it's he said and she said under a certain dollar amount. But over $500, what the lady at McDonald's is supposed to do in almost every state code is go outside, find out who just placed this order, write some sort of a contract saying, you will pay me $500 for these hamburgers. And that way, if you do not pay the $500, you are now bound, and I will take you to court, and I will definitely win. So that's what the statutes of law means. So when there's a certain dollar amount, it's all he said, she said. And if you're a businessman like McDonald's, and somebody orders $1,500, $501 worth of Happy Meals, and then the guy pulls up, there's a couple of crazy kids, college kids made this ridiculous order, and they pull in to up to the window, and they don't pay, McDonald's has to eat it if they don't have a contract that's worth $500. If they couldn't prove it. So that's where the statute of law is. So if you folks actually want to learn what the statutes of law actually bind, is like a marriage has to be in writing, in your state codes. Any contract that's going to take to perform a service for more than 1 year, or a transfer of land needs to be in writing, or say an executive order of an estate, like you're creating a will or a trust, that has to be in writing. So there's no he said, she said stuff, or like a sale of something over like a certain amount of money. So there's certain conditions that must be in writing to hold in court when you're dealing with a credit card company, mortgage company, Macy's, McDonald's, a taxi driver, a hotel, anything. Under $500, basically, you get into court and do this arguing, he said, she said nonsense. Over $500, if the person that's moving a claim against you, like a credit card company or a hotel or a taxi driver or McDonald's, does not have it in writing, they're going to lose, because they are to know that according to the code in which they're chartered and licensed to operate under, if they want to make a claim for anything over $500, it better be in writing and it better be signed. Because I helped somebody get out of a he said, she said nonsense because the person who was making a claim against them wanted $1,500 in compensation. And I told the lady, just said, hey, settle, work on a private side. And the guy said, the lady, F you. I'm not settling for anything less but $1,500. So all I said to the lady is, okay, hang on a second. I got the Code of Virginia. I want to pop it up. We're going to hand it to the judge. And the judge is going to say a simple thing to the man. Do you have this agreement between this and you, you the man, who's a state licensed surveyor, and this woman, do you have it before this court? Do you have the law, the contract, the law? Do you have the law before the court? And the man said, no, this is all verbal. And then the judge just said, case dismissed. And when the court thing was over, I tried to still work with the land surveyor, but he was extremely upset. And all I was trying to tell him was like, look, she'll still work with you on a private side. He was furious. And he didn't want to hear anything. Because I tried to tell him, look, if it's over a certain amount of money, you are licensed to be a land surveyor in the Commonwealth, and you have to abide by certain rules. Now, if it's $499, it's basically he said, she said, and the judge probably would have tossed it to you, because why else would have you been on that woman's land? There must be some sort of an agreement, or you wouldn't have appeared. So there is some sort of a contract, an unwritten contract, an unwritten law, because it's self-evident that there's no reason in the world you just go hop on this lady's property and just start surveying nilly-willy. So this lady's like, yes, he did survey the land, but we agreed on a less of a price. And she was like, I'm willing to pay you this, but I'm not willing to pay you that. So the judge threw that case out on the poor land surveyor guy. So like I said, that's what I'm trying to explain to you folks, that when certain companies come after you, it's all he said, she said, up to a certain amount. The same thing with a marriage. Just because that woman points a finger across that courtroom and says you're married, according to the state codes, they're going to say, do you have it in writing somewhere, ma'am? Because if the man says, I've never seen that woman in my life, that is not my child. I mean, before people were able to do a DNA test to prove those weren't your children, some woman could just walk into a courtroom and say, that man, this is his baby. And I got 59 witnesses behind me to say so that it's true. So it's just got a little dicey for like somebody who was rich or well-to-do who just won the lottery. All of a sudden, somebody's claiming that they're their daddy. So, like I said, that's why certain things, should be and must be put in writing. For everybody's safety. It's not just for being sued, but the person who wants to do the suing. The land surveyor got flat out nothing in for his labor. So he should have put it in writing and had the lady sign it that she's willing to pay $750 or $1,500 or whatever their agreement was. So I'm just explaining to you statutes at large. Statutes at large is a very important concept when you're dealing with any kind of relationship. I don't care if it's credit card. I'm just trying to make a blank generalization for anything that you folks might run into out there, not just one specific credit card debt or mortgage or a title company. I'm just trying to throw a whole blanket thing out there for you folks to try to grasp what's going on here. So like I said, with me and Greg, all we were basically trying to say is make sure that the parties understand that each other have some sort of relationship between the parties. Then you make sure that that there's some sort of evidence of proof, and you can rely upon statutes at large. And I'm almost sure you could type it in, or I could actually send it to you folks. If you guys email it to me, I could actually send you what statutes of laws means. That I wrote like a little dictionary thing, and I could actually broke it down in very plain, simple terms that you folks can understand. It's called statute of fraud. So, and it comes from 1677. So, if you guys want to Google it for laughs, it's a really good one to know. Statute staples is another good one to know, but I'm not doing that right now. That has to do with the IRS, and it's 100% bona fide, and it's true, and it's dead on accurate. But right now, we're just going to do statute of fraud because these folks want to know how to deal with going into court and out of court. Okay, the next thing that me and Greg were talking about was saying mean, you could have, if a representative of a fictional entity is going to represent the complaint or the claim or the breach of the contract or the debt in open court, you want to make sure that that person has a delegation of authority or a power of attorney to move the claim. Like the man who was talking a little earlier, I don't know if it was Chuck or Dallas, is the man who was working in a construction company. He was giving us this great solution. I'll pay you 20 cents on the dollar, 10 cents on the dollar, 5 cents on the dollar. Well, okay, before you even start doing that, because that's insane, and I don't want to say that, before you even start doing that, you make sure that that person on a phone call talking to you has the delegation of authority to negotiate that debt. I mean, I'm sure I could go online and I could find all kinds of people with all kinds of debt to everybody, and I could just start making cold calls. And I could start saying, hey, Mr. Idaho, hey, Mr. California, hey, Mr. Nebraska, you owe Bank of America, blah, 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 blah. And I'm here to propose an offer to you for 5 cents on the dollar. We'll wipe that out, and we'll send you all kinds of certification and verification and whatever paperwork you want us to sign, and we'll deliver, and we'll send it to you that debt is now satisfied. Okay? That's crazy, because first you need to make sure they have the delegation of authority. And just because they went online and they found, like say I wanted to go online and go to Harvard or Yale and print out a college certificate and say, oh, look, I graduated from a master's degree from Harvard Law School. Just because I copied and pasted and I made nice bond paper doesn't mean I actually have the accreditation to match what says on that piece of paper. So just because this man whips out this beautiful bond paper, delegation of authority, everything is stamped, signed, sealed, all kinds of nice gold fringe and all kinds of silly stuff, red borders and everything else, don't trust that piece of paper for a heartbeat. You send it over to whatever the debt collection agency or the loan department for Bank of America or Capital One, and you say, hey, have you ever heard of this guy? Because he's acting in your name, and he's stealing not only my money, but he's interfering with your right to collect on a debt. So make sure that the delegation of authority doesn't just come from the guy who claims to be the guy legit. He's like, oh, yeah, please. You're the legitimate guy? Yeah, please. You know what? Thank you. You know what? I didn't just wake up yesterday. You know what? I know what I'm doing. So make sure you get the delegation of authority or the power of attorney if you're dealing with man on man. If somebody's saying, well, you owe my mama money and she's in hospice care, so now you're going to have to work with me. Just say, okay, show me the power of attorney. Show me where she signed it. Show me. So first, then make sure you don't forget about the delegation of authority.
Hey, Karl, before you go too far, can I ask you a question about that?
Yeah, sure. Go ahead, man.
It's Dallas. Okay, let's say they do have a legitimate delegation of authority from this person that hired them to represent them or a power of attorney. Can the person that signed that delegation of authority or power of attorney be subpoenaed as a witness?
Oh, absolutely. But like I said, then you got to be careful, because subpoenas only hold basically a 100-mile range. So it's going to be interesting if you demand that they appear, and they'll say, well, basically the code of, wherever you live, Texas or wherever you live, is going to say that the rules of court say that you could only subpoena them from 100 miles away.
Okay.
But wait. But if you look at Jennifer Flowers versus Bill Clinton back in 1997, she subpoenaed him to appear in Arkansas District Court. He tried to talk about that. Right. He tried to say, I'm in Washington, D.C., and I'm an awfully busy man. I got my finger on a nuclear button, and the Russians are about to drop a bomb on us any minute. So I'm sorry I can't make it to Arkansas at this time. It's inconvenient. Sorry that she believes I grabbed her ass, but you know what? So what? We're talking about national crisis. We're in the middle of a war with Kosovo. We're bombing all these Serbian people. We're killing all these Christians. We got to protect the world from these crazy Christians. We're busy up here. I can't go to answer every claim that somebody makes in some bozo court in the middle of Arkansas or the middle of Nebraska. Next thing I know, I'm going to have 500 women claiming I grabbed their behinds. And they're all true, but what do you want me to do? Leave the presidency and go down there and answer them? The United States Supreme Court said, absolutely. If anything, you, more than anybody, since you're a public servant, you have to appear when your public calls you to serve. So it doesn't matter you're the president. You're actually way under Jennifer Flowers. You're not above her. You're way below her. I mean, the United States Supreme Court decision was beautiful. I thought they were going to tell her you're going to have to wait until he's done being the president of the United States, because that office and that position is in control of the world and with the free world, and we will all die, and the economy is going to collapse, and we're all going to be eaten by whatever, because the president, Bill Clinton, the leader, the fearless leader, is going to have to be ready to lead us to charge into battle at a minute's notice, so he doesn't have 2 or 3 weeks to waste about some frivolous, well, he grabbed my behind when I was bringing up some towels to his motel room when he was the governor. You know, they're like, no, you drag your butt down there and you work this out with her. So what he actually did was he flew her up with his attorney to Washington, and they worked out a settlement that way. But see, just because you're thinking that, well, the subpoena rules 100 miles, honestly, if you want to go about the subpoena rules, look, and they'll say, oh, no, you can't. This I'm just trying to tell you, Dallas, use the Jennifer Flower case. Bill Clinton said, whoa. I don't care if he's the president of IBM. I don't care if he's the president of Bank of America. I don't care if he's the president of the United States. If I'm going to make a claim, if he's making a claim against me or I make a claim against him, he's going to come and answer this claim. Okay, so I hope that helps a little bit answer that.
Yeah, it does. That's exactly what I expected to hear because, because I believe that there has to be another man, woman, they're making the claim against you to make it valid. Otherwise, they have no standing. So that's why I was asking. And then, I mean, you could go as far as going, well, you delegated the authority, but what personal firsthand knowledge do you have of the actual situation?
Right. I'm going to get Greg back on board. So, Greg, now remember what you were talking to me. You were saying 9 out of 10. 9 out of 10 people who are making a claim against you will not be able to validate their debt. So go ahead, Greg, and explain what that means a little bit. Are you there, Greg from Illinois? Greg from Chicago? Hey, Greg from Chicago. Greg. Hey, Greg. Are you there, Greg? Greg from Chicago. You there, Greg? Did you mute yourself? I had to mute you out because we heard you burping and sneezing and everything else like that. It sounds like a cattle crossing.
Hey, Karl, you there?
Yeah, Greg, I had to mute you out because it sounded like a cattle crossing, and I realized it was you and not the cattle outside. You were sneezing and honking.
Actually, it probably wasn't me at all. The only thing I'm doing is chopping up vegetables here at the kitchen sink.
Something was going on. I had to mute you out because it was keep a train of thought going on because it was derailing. Yeah.
Anyway, I was just talking to Mike B, and he had an issue that was interesting right in about this topic, and so I said, "Hey, Mike, why don't you jump on the call with us and throw that in there?"
Well, what's his name?
So,
his ID that
it's Mike B from Virginia. I don't know what it's going to come up under.
Okay.
But,
okay, great.
You know Mike. You know Mike from Privatus, right?
Right. I like Mike. He's a good guy. So
he's got an issue that's kind of interesting. I think you and I talked a little bit about it earlier, and he could bring up a little bit more about it. It's kind of an interesting kind of like man-to-man claim. So,
okay, well,
but it fits right into what we're talking about.
All right, that's wonderful. We're going along pretty good here, Greg. We've got a good steam going here. 9 out of 10 people we were talking about, or 10 out of debt collectors, or 9 times out of 10 of these creditors who are claiming that there's a debt we were talking about, you said they will fail to validate the claim. Now, why do you believe that?
Personal experience.
Yeah, do it slow. Yeah, do it slow, Greg. Why do you believe that?
I believe it from personal experience.
Okay, well, tell us.
And the numbers of debt validation efforts that I have attempted, following their rules, following statute, you send them a request for certain information, and they send you back a computer-generated cover letter that basically says, "We don't know what you're talking about. Pay us some money." And that's pretty much how the conversation goes.
So what was this stuff, the information you were basically asking them to send to you?
I was like, please send me proof that this agreement exists, that the amount of money that you're charging, that you want me to pay, is exactly what I'm supposed to pay. Show me what it was that I did or contracted to do or used. If it's a credit card, what did I charge? Show me that all of the fees and everything else that you've thrown onto this thing are actually valid. Show me that you didn't like add a bunch of other crap that has nothing to do with our agreement. Show me that this is a clean, it's kind of like if I bought a hammer from you for $10, you charge me $5 interest over 6 months, and then close the account. I figure I ought to pay you $15, maybe $16 for mailing, and if all of a sudden you want $150 for that $10 hammer, I'd like to know where the extra $140 came from.
So let's stop right there. That's great. That's good, Greg. So not only tell them, okay, this is what I'm saying, folks, see, because this is what I would do if I was the credit card company. I'd say it's all in the contract. Read the contract. It's too font. It's 10,000 pages long. I would tell them, no, highlight it. Highlight the terms and the conditions in the contract, because until you do that, I think you're just making this up. I don't think there's any valid explanation within that contract that could possibly legitimize what you're claiming or what you're. So please highlight it and send it to me. Instead of you trying to read these 10,000 pages as like, well, it's in a contract, just read it. That's not my job. No. If they see it's in there, they wrote the thing, make them bring the law forward, because that's the law. Between you and them, that's the law. So if they're saying there's a contract and you signed the thing and you made this private law now between you and them, you have to live and die by this law. You might say they're a bunch of Shylocks. That's fine. But you knew what you were dealing when you danced with the devil. You knew you were going to get burned. So you still got to make the devil show the terms and the conditions or the clause. You have to show it in the contract. So go ahead, Greg. What else would you ask these people to produce?
Well, if we're talking about the original creditor, you don't have to worry about third-party authorization. If you're talking about a debt collector, we know that a lot of, now I want to say we all know this, because, let's assume that there's people on the call that are here for the first time. What a lot of people do know, presume, thank you for busting me on my favorite bad word. All right, yeah, I know, it is, assume is to make an ass out of you and me, right?
Go ahead.
All right. So anyway, in most cases in contemporary business, when a bill or a debt has been, an alleged debt has been passed from the original entity to a third party, that third party has either paid those people cash, written them a check for that debt on pennies on the dollar, or agreed to a commission at a fraction of the cost. All right? And in addition to that, most of the creditors that are out there have insurance policies, so that if they ever have an uncollectible debt and it goes to the third party, they actually get paid for the debt before it even goes to the third party. So they can write it off. I mean, this is gorgeous how they have it set up. You can get a debt with them. They can then write it off and remove that from their profit, and they can collect the insurance on it and not have to claim that as profit because it's an insurance claim on a damage. So they get paid twice. And the third-party debt collector pays them something, so they're getting paid like maybe almost 2.5 times. And they're made whole. So they're made whole, and they're coming back and telling you that they're not made whole and you owe them this money. So you have to wonder, well, if you've been made whole, what am I supposed to do? If you haven't been harmed or injured, and no man has been harmed or injured, and you guys, in your wisdom, created this banking system and insurance system that makes it impossible for you to lose, why are you bothering me?
Okay.
Why aren't you?
Stop there a second, please. All right, you're doing good.
Go ahead.
But what you folks might not have just noticed is Greg went from square dancing to tap dancing. What Greg just did is he just shifted jurisdiction. And I don't want to shift jurisdiction yet, Greg. I want to still concentrate on statute. Concentrate on the law of the contract. Don't try to throw a trump card in because you danced with the credit card company. So you bound yourself with the devil. You made a deal with the devil. You're going to get burned. There's no doubt about it. There's somewhere in that contract where you get fried. So let's just work with trying to stay in honor with the person that you decided to dance with. Okay? Go ahead and keep going with that.
All right. So if you don't know anything about what goes around behind the scenes, and you think the only thing that exists is you think this credit card company actually reached into their pocket and gave you money in order to buy that refrigerator, which they didn't, but you believe that because that's what the contract looks like. Okay, the contract looks like, Visa, MasterCard is going to reach into their pocket and pull out $500 for me to buy my new refrigerator. Okay, and so if you're old-fashioned farmer guy from 1800, you're thinking that's exactly what happened because back in 1800, that's the only thing that could happen. All right, there was nothing else. So you believe it. So if you believe that, then you're thinking, well, I should pay this guy back because he put his money out there to buy my refrigerator, and so he really owns my refrigerator, so I pay him off.
Okay. What I'm trying to say here is I really don't want to go down that path because a credit card company did not give you money. A credit card company did not give you paper. A credit card company gave you what?
Credit.
That's right. So I don't want to hear anything about money because money is just a medium of exchange. Now, whether I trade you 300 pounds of cow manure and you give me 600 pounds of the best Chicago bratwurst that you could find, that's money. So I don't want to confuse people with thinking that a credit card company gave them or did not give them money. They gave them something which they believed was worth value to them, or they would have never danced with these people or accepted their conditions or their for value. So all I'm trying to say, Greg,
I know you don't want to say money, but for 90% of the common man, they think that represents money.
Okay. All we're trying to say is what things does the credit card company or their representatives or any debt, somebody who gave you something and demands something now, the restitution, what do they need to present to you or to court to keep moving their claim? Now, don't go down on money. Don't do any of this other nonsense. We're just doing a generalization for anybody who owes you a debt, that believes you owe them a debt. What do they need to establish?
Anybody who wants to move anything through a court has got to bring the law and the facts.
Okay. Now, we're not talking about that. When I said to you before, what we were doing was like saying, how do they validate and produce the facts and the evidence to move the court? That's the question. You said 90% of them can't produce and they can never be able to validate the debt. Now, how would you say that they need to bring forth to validate the debt?
They need to bring forth a man or a woman who knows that this is true.
Okay. Now, stop right there a second, folks. This is where this Greg just did his jurisdiction change on me again. Okay. This is common law. Okay. Now, in contract, if you made a deal with Coca-Cola, Coca-Cola does not have to bring any man or woman forward to bring forth because you reduced your status of a man and you merged it with a fiction. So for you to get something of value from a two-dimensional world, you reduced your status to that of a two-dimensional entity as well. So they are going to demand from you, this two-dimensional entity is going to say, well, we demand from your person what we agreed as a medium of exchange, money, or what we deemed had value. We are going to give you 10,000 cases of Coca-Cola, and you're going to give us 10,000 widgets or $10,000. So this is how they're going to bring you into court. Now, can you play the old trump card and say, oh, well, this is common law land, and you know what, I'm going to beat these Coca-Cola out of every damn Coca-Cola can they sold to me. They sold me 10 million Coca-Cola cans, so I'm going to beat them out of their money, and I'm going to say, there's nobody with any first-hand knowledge that could say that signature on that piece of paper between me and Coca-Cola is legitimate. You know what, honestly, technically, yes, you people can do it. Do I think it's disgusting and evil? Yes. And you're worse than a lawyer to me because you know how to take advantage, how to take candy out of a baby's mouth. Because, like, say Greg had a company and he just decided to make his own new cola company in Chicago. And Greg had a whole bunch of stockholders like his mom and Mike from Privatus and everybody joining in and giving Greg money to build up this wonderful corporation. So Greg created a corporate entity. I come along, Karl, because I know common law. I'm going to order 10 million cans of Greg Cola. So I get Greg's Coca-Cola coming to me. I tell Greg, prove that's my signature, prove this, prove that, prove this, you're screwed. Is Karl wind up with 10 million cans of free soda? Absolutely. What happened to all those stockholders? What happened to his mom and everybody invested in that corporation? They trusted me that I would do a certain thing for return for something. So now, what's happening now is it's been going along so smoothly for the corporations to keep doing this to people. All people have to do, what Greg would have to do then, as a good businessman, would say, Karl, honestly, this stuff is going to get wacky. You guys are starting to drag us into common law. You guys are starting to do this to us. We're losing exponentially. We're going downhill fast. So now, we're going to have to slow this process down. So, Karl, if you want $10 million of great Coca-Cola out of the great Coca-Cola Corporation, Karl, we're going to need a $10 million bond. So that way, if your check bounces or anything happens between the transaction between you and then dragging common law, we're holding your freaking bond. So you're going to sign this $10 million over to the corporation known as Great Coca-Cola. Okay? Now, what I'm saying to you folks, this is what's going to happen. It's commerce is just going to slow down because the corporation is going to say, how do we get somebody to use their debit card or credit card or sign a mortgage without making sure they're bonded? Because everybody just did it on their word. You'd have a credit rating, and your credit rating just established based upon your acts in the past, your inactions in the past, how good your word was to paying off a debt. So if they just say, look, everybody's learning how to beat us, you know what? Either they're just going to all wrap up, or the banks and everybody's just going to wrap up shop and say, look, like there's only one person out of 100 on this planet that lives in the United States. You know what? We're going to go to China. We're going to go to India. We're going to Africa, where there's 99% of the world lives. We don't need you, United States, anymore. You know what? You guys figure out how to trade rubles or wampum or seashells with each other anymore. You don't want to deal with us anymore. You don't want to act honorably with us anymore. We're not going to deal with this bond nonsense with you people. You know what? God bless you. We're going to unbolt all your machines and factories, and we'll just ship them to China, and you guys could just work in McDonald's for the rest of your lives because we're not going to extend credit to you people anymore. How hard is it to get a loan nowadays? It's almost impossible. How hard is it to start a business any day? Because the banks are scared that they're not going to be able to, you could say, screw over the people anymore. So they're afraid that these people are going to learn how to get out of any kind of credit card debt or any kind of loan or any kind of mortgage, and the people will learn how to do it. But then what are we going to have? So this is what I'm just saying to folks, be careful. You guys are going to get what you wish for, but what's going to happen to the next generation? The people who try to establish credit or get homes or try to get businesses going. That's why I say it's so important if you want to play in their jurisdiction, if you want to play in their two-dimensional world, believe me, if the best you could do, like I say to you folks all the time, is say, look, by my word, in good faith, the best I could do, I'm out of a job right now. Greg, the best I could do right now is give you $2 a day for the next 365 days, whatever, until I pay the debt off. Believe me, as soon as I get back on my feet, as soon as I get a job, as soon as I win the lottery, believe me, you will be the second person that gets paid off. First I'm going to say, praise to Jesus, whatever. But you're going to be the very next person I want to pay off. And there you go. So this is what I try to say to folks. Greg's going to bring you down a second jurisdiction, common law, and how to wipe out these people and get them off your back. But if so many people do it, like I said, it's going to be a domino effect. And it's going to be a house of cards, and it's going to collapse. So this is just my belief. This is what I really believe I could see happening. So if you want to play in the two-dimensional land or three-dimensional land, or that's fine. But
actually, Karl, if you think about it, though, I'm sorry for jumping in.
No, go on, man.
But at the same time, two different bad things happen. One, people start feeling entitled, and two, banks decided to really go berserk on usury. If you really stop and think about the fact that the prime lending rate right now from the Fed to the banks is 0.1%, just about nothing, right? The banks get printed money for free. Then they charge you 18 to 21% interest on borrowing. They are at a point right now where their profit margins are obscene. It is absolute, gun to your head usury. All right? So what happened is that instead of everybody being in the middle and being honorable, the people became more and more dishonorable. And the banks became more and more dishonorable to the point where the chasm between the providers of currency and the users of currency is so wide right now that it's unresolvable. And your prediction of having a new economy and a new form of currency and everything like that, I think that that's inevitable. I think that the game that was set up, I personally think the game that was set up is at an end. Okay, I don't think it can't go very much longer. And if it does, it can only be done at the point of a bayonet. And I think that there will be a new development of currency. I think that in the short term, it's going to go back to what everybody can trust, and that is straight barter. I'm a plumber, or I know how to do plumbing. I'm going to fix your sink, and you're going to give me a bushel of corn. And a lot of that stuff is already going on outside of the large metropolitan areas. If you go into Iowa, Nebraska, Southern Illinois, Indiana, throughout the heartland, I don't know how things are on the coasts because I'm not familiar with the internal economy. That I know my 10, 12 states over here, and a lot of people are doing that now. And it's all hush-hush because nobody wants to talk about it because they all still are afraid of the IRS. And so a lot of people are just doing that, and it's all being done on a handshake and a nod, and, they're trusting their neighbors, and their neighbors are coming through. And that kind of stuff is really happening. And that's how ordinary folks in the heartland are dealing with the problem.
But believe it or not,
basically opting out. They're just opting out.
Believe it or not, it's funny too. The reason why the banks don't want to loan money is because the interest rates are so low, and to them, they're waiting for the interest rates to rise to start loaning money out again.
Well, only on. But Karl, be clear on that. Only on secured loans.
Right.
They are under a lot of scrutiny when it comes to a secured loan with a collateral, but they have no scrutiny when it comes to credit cards, and that's why they push everybody to credit cards.
Well, what I'm saying,
they could do whatever they want.
What I'm saying is venture capitalists. Venture capitalists, they're sitting on their money and they're just waiting for the interest rates to go up. So people might be, like they're saying, these corporations and these college institutes are sitting on billions of dollars just waiting for the interest rates to go up so they can put the money back into the economy. But at this point, they said, you know what, it's better for us to stick our money under our mattress than to put it in an economy that might go under. So until they actually see that people are borrowing again, because borrowing means growth. Borrowing means there's corporations starting up and there's a demand for currency. There's a demand to spend again. So like George Bush said to you guys after 9/11, don't let the terrorists win. Go out to those malls and keep buying products and keep buying Nintendos and keep buying houses. Just keep the money. Just keep the economy going. Don't be afraid to go out of your house. Don't be afraid to go to the shopping mall. Go out there and spend, spend, spend. So as long as they see there's a demand for the currency, the interest rates will go up. And so the venture capitalists, people who might be millionaires or billionaires will feel a little less hesitant to putting money back into the stock market or putting it into their local communities if they believe there's going to be real growth. But until they believe there's real growth again, they're just going to buy bullion of silver or gold ingots, and they're going to stick it under their mattress and just wait for the economy to collapse. So, like I said, that's why I just try to say everybody, if everybody just starts to learn to keep their word and play fair and square, I just think this is the way to more go at it than try to figure out who's going to screw the other side first. Are we going to screw the banks, or the banks going to screw us? Who's going to do? Whose turn is it to screw who now?
When it comes to a contract, if the terms of the contract include a privacy clause, for example, Karl had mentioned, I'll mention now, we have a colleague who had a contract with a co-colleague that specified that the thing would remain in private, and there was a part of the clause in the contract that said anybody who brought this into a court had to pay $1 million to the other party. Period. It's part of the contract. That all these things, if there was any discrepancy, it had to be handled in the private through a private education process. All right, not public. All right. So this guy goes and gets picked off, sends it to the Attorney General of Illinois, thinking that he was going to bust this guy up, and the Attorney General sends the other party of the contract a copy of the contract that was sent to her, as well as a letter that says, "Dear sir, this guy sent me this stuff and complained about this, this, and this. Would you like to prosecute?" In other words, the Attorney General of Illinois recognized that this guy had breached the terms of the contract, and as we've said many times in this call tonight, the contract is the law. So he broke the law, okay? And the Attorney General was willing to basically be a star witness against the guy who sent it to the Attorney General. Pretty silly, isn't it? You know? So be very careful on your contracts. If they're not supposed to be brought into the public, don't do it. And if you do have a contract or you want to make a contract with somebody, consider the aspect of adding that element to your contract to ensure that it stays in the private and it doesn't go into the administrative court system. Put a mutual, "I got to pay you $1 million if this goes to a public court." And you know what? Nobody's going to sue you in court. They'll work with you because nobody's going to pay $1 million just to whine. Okay? That's just a little trick in contracts. Okay? And lastly, if someone brings a contract, if a guy brings a contract into court, again, as I said earlier, it is the contract which is the law of the contract.
Greg, there's another thing that I say to folks all the time. If anybody wants a contract written, pay Greg because he's good. He can write good contracts. But let me throw something else. Me and Greg were talking about this the other day because let me see if he's paying attention when I talk to him, which I think he does. So just say that there's a contract and you can't force these other people to respond or react or whatever. What else can you do to a court, Greg, if the other side doesn't want to show up? What can you do?
If the other side doesn't want to show up?
Yep.
You can get a summary judgment.
What do you mean?
In other words, you still file your claim. You still file your claim, and you put in an order for a summary judgment. And you know, if the other party defaults, it's the same thing as if the mortgage company wants you to go to court and you don't show up. They give a summary judgment and the judge grants it because you didn't appear to dispute the charge or the claim.
What I'm saying is, when we were just explaining about if the second party, if you have a two-party contract, like say you have a private contract, a husband and wife, or a doctor-patient relationship, or an attorney-client relationship, or a priest and what do they call it, parishioners, private information. And
I prefer a man and 300 cats.
Okay, and they don't want to disclose the private contract or the private agreement, or they don't want to air their dirty laundry out in public. Nobody on this planet can force somebody to disclose the information of a private contract into the public, regardless of what that contract is about. There's no power on this planet that can open up a trust and intervene into a contract if all parties don't want it. If the two parties are a part of this, that's why, like a marriage license, you're allowing the state to be the third party intervener on day one. So if it was just a marriage license, it was just a marriage between you, or it was just that's what I call it. So when you consent, a consensual connubial relationship with a woman to procreate and produce offspring. There you go. The government can get involved. Whatever private contract you have written between her and him, the two people, she can run to court and do whatever she wants. Like Judge Greg just explained to you, the guy says, "I don't think this disclosed."
I mean, and that's really important. And you know, as an anecdotal little piece, my girlfriend in college and I had thought we would get married. We didn't because I wanted kids and she didn't. So we went our separate ways. years later, she ended up becoming an attorney. And we connected again, through alumni stuff and everything. We started talking. And we actually, before I got married, we're talking about this stuff. And we actually wrote, a cohabitational kind of contract that would allow a man and a woman to live together under a private contract so that they didn't have to become party to the state, or the state didn't become party to the marriage. But at the same time, contractually, it gave the man and woman all the rights that would appear to a married couple under the state law. We actually wrote that, like back in 1992.
You're breaking up, Greg. You're underwater again.
So we wrote this agreement, back in 1990 or 1980 or something like that. I forget when it was, because we thought that was really interesting. Even though she and I never got married, we both agreed that we never wanted to get married. And she became a lawyer, and I became a goofball, right?
Wow.
And
I was saying, Greg, I was hoping that you were going to catch on to what I was saying. How do you kind of try to force the other person to realize that it would probably be beneficial for you to try to settle a matter on a private side before you have to drag in the court? Okay, Greg probably has the thinking cap on right now.
But the way I said that is, if you have the ability to be writing the contract at the beginning,
right,
you put severe penalties into the contract for disclosure.
Okay. Do you see, Greg, that's a lovely answer, but do you see the answer I wanted you to say was a DJ?
Oh, Bill.
Okay.
Okay, you didn't see I was going there, did you?
No, I didn't.
Okay.
Because I was thinking one way. All right, go ahead.
Right. What I was hoping Greg would stumble into eventually, I was hoping he was going to say that you wanted to go for a declaratory judgment. So under the Federal Rules of Civil Procedures, Rule 57, it's easy for me to remember because it's a 57 Chevy. It's Rule 57, and under Title 28, I think it's 2201. And all you're basically doing is saying, look, Judge, you like Greg said to me, he's like, hey, you know what would be fun? He says, why don't we just make controversies between you and me, Karl, and we go to court, and we try to get judges to make rulings and see how this stuff will play out, and nobody's really getting hurt. I said, called barratry, and that's abusing the court system and the resources of the community. No, we can't do that, Greg. But there's something called a DJ, the declaratory judgment, that if you have a controversy that truly exists between you and somebody who really doesn't want to come forward and get involved and thinks they're going to sneak out of whatever they want to do, you're just going to propose this complaint. It's not a claim, it's a complaint, where you're just whining about something to a man in a black robe. And the man in the black robe is going to saying, well, if this controversy ever appears in this court, and if what you're saying is true and accurate, this is what this court would decide. This ruling is not binding on any party. It's just an opinion of what this court may do if these parties ever appear before us. So then you can hand it to the other side. Say, look, now I'm either going to sue you, and does this pretty well reflect what really happened between us? The complaint I put before this man in the black robe, it's like, well, yeah, it kind of sounds exactly what happened. Do you see what the man in the black robe ruled? Then I would rule in my favor. Like, yeah, so now do you really want me to sue you in court? So you could just have the judge repeat what he just wrote here in this declaratory judgment? And do you want him just to actually put it down as the judgment of the court? That, would you rather do it that way? How do you want to do this? So it's called a declaratory judgment if you're just trying to find an opinion of the court and how they may rule. That's a pretty good way of doing it.
Yeah, I forgot about that. That's why I was going with summary judgment.
But that's what I'm saying. If you're just trying to test out theories, that's how you could basically do it without, because people got arrested years ago for doing that silly stuff on me and Greg, like, oh, let's make $1 bet that the judge is going to proceed my way. And then you just file a claim against each other. When you get caught doing that, you're going to get in big trouble. But this is another way to test it out and just show the other side that you mean business. And if you drag me to court, this is what's going to happen. And now when you talk about like a statutory grand jury, that's basically what they do. They had C-23. Usually it's 23, not 25. Usually, but because common law is supposed to be 25. But whatever. But what all grand jury comes down with an indictment says, basically telling the guy who did wrong, you got 23 people on the jury here that found you guilty or wrong of doing something. What do you think is going to happen when you get in front of 12? It's going to be a lot easier to convince 12 you did wrong. So if the feds or the state are having a grand jury indictment against you. If I was you, I'd cut a deal with the feds. I'd cut a deal with the state. So anytime anybody gets arrested for a felony, the first thing you do is you demand to be indicted. So like I said, there's some man on the call. I know he wants to talk about drugs and felonies. The first thing you're going to want to do is you want to demand a indictment to come down from the grand jury. And you're going to want to present your case and your side to the grand jury. Now, a lot of people say, well, no, the county prosecutor, state prosecutor won't allow you to do that. Baloney. You could address the grand jury if you want to. And you say, I have the right to present the evidence, all the evidence, not just the prosecutor's evidence, my evidence as well. And if they won't allow you to do it, you could actually hand down an indictment. You could actually hand down a complaint or a claim to the grand jury. And if the feds are coming after you, you could go after the feds and tell the grand jury to investigate the feds and then accept all your evidence. And then they're going to investigate your claim against the feds. So it's interesting because the grand jury is an independent, like tribunals, an independent organization altogether. And they get to determine whether or not there's any merit to the claim. So when you get indicted by the grand jury, you're pretty well going to believe that you're going to lose when you get in front of a petite jury of only 12 people. If the grand jury found you guilty, well, the odds are you better make a settlement with somebody quick. Well, you better figure out how to file a claim against the other party because you're going down. But that's always a good test to put your feet in the water to see, well, what's going to happen when I go before a real jury? What's the odds of me getting out of this? Not just saying every time you get indicted by a grand jury, like O.J. Simpson did, not because you're not going to win in criminal court. You know, you might not get convicted in criminal court, but you're going to lose in civil court. It's pretty good that the majority of the population, if you get indicted by a grand jury, pretty well feels the same way the grand jury feels. So it's usually a pretty good indication that you better cut a deal. But most times if it's chicken nonsense charges and on a felony level, like this guy who released 12 balloons in Florida and he got hit with 12 felony counts for discharging into the atmosphere helium, he's got 12 felony counts against him. So if I was him, I'd say, you know what? Put this before the grand jury and let the grand jury indict me. And the grand jury probably laughs. This is ridiculous. So when it's chicken nonsense charges, and it's a felony, even if it's misdemeanor, I want to be indicted. You tell them put that in front of the grand jury. Because there's a ridiculous code, a ridiculous carbon dioxide act of whatever, Al Gore nonsense. I ain't putting up with this. I want to be indicted. I'm not answering to any of these charges. These are ridiculous. So you can try to do it that way if you want to do it. I'm just giving you guys all kinds of different options how you can go with this.
All right, I'm going to leave it there. Back tomorrow. We're going to continue with the series. And then, God willing, if I'm feeling a bit better, I'm all healed up, I'll run my mouth a bit more, maybe sometime next week. We'll see how it goes. I'll take it day by day. I'm not going to make any declarations either way. All right, blessings, folks. We'll see you later.
Recon. Put you in the sickle for the harvest is right. We ain't down for wickedness, false prophets a lie. Woman to the wicked grass of line of sight. Unquenchable flame stars fall in the night. Shemayim snap the scroll, mountains fled in the anger. Hills a flock of rams skipping special forces, recon angels. Really by no labels, we bout labor for the source. Wells up in infinite, waters coming forth. Spiritual revival, dehydration shall I pour. Kept the run down to the mouth, cool floor. Kingdom heaven in me is parts of the morbid head. Treasure like deep in you keep to the never end. We all a ray, a fragment piece of the sea sledge. Point of a center, he segment filled in with ether. Hit me on the end, you're passing a present teacher. Pre-sealed and covenant in Nehemiah, not Easter. We all a ray, a fragment piece of the sea sledge. Point of a center, he segment filled in with ether. Hit me on the end, you're passing a present teacher. Pre-sealed and covenant in Nehemiah, not Easter. Not a game, stolen the soul arrangement. Adversary in the details, mirrors and smoking angels. Incriminating emails, fake news, read the paper. Pimping who been printing, it's all designed to take ya. Division in your cells, almighty sustain. Ain't got hard relying on nothing else. In trouble, it's all vapor, elder wind in the sails. The water, the whole rainbow, reclamation, just a vessel, a wrestle. Jonah, you came for. Stay mind, blow it holy. Lord, if they only knew how they controlling you, thought still a slave. Look how they holding you, enemy scoping you, word on my wing. Stay mind, blow it holy. Lord, if they only knew how they controlling you, thought still a slave. Look how they holding you, enemy scoping you, word on my wing. Force tremendous, Bill Adam breath, living dust, mushy for the enemy, burnt down like a Dutch. Once upon a distant, dirty sackcloth in the ashes. Truth don't grow with mischief, prayer get raised about the ashes. Save me from the mire, I would fell of not your pasture. Had you not an anchor, if you save me, I'll be thrown to the thief, leech, mind of the corn. Stone in the sling, sing signs in the storm. Rock foundation, time echo with the north. Recon over game, wings fly with the force. All purpose type material to camouflage the course. Tiger stripe, orange, red drip from the source. We all array your fragment piece of the sea slits. Point of a center, he segment filled in with ether. He'll be on it then, you're passing the present teacher. Pre-sealed and covenant, Nehemiah, not Easter. Stay mind, dwell with holy. Lord, if they only knew how they controlling you, thought still a slave. Look how they holding you, enemy scoping you, word on my word. Stay mind, dwell with holy. Lord, if they only knew how they controlling you, thought still a slave. Look how they holding you, enemy scoping you, word on my wing.
You can't treat him like any of the other niggas around here, because he ain't like any of the other niggas around here. You got it?